Now, a series of deadly arson attacks in schools in Kenya have raised serious legal questions as who is held accountable for them. Our reporter Bentura Kwamboka looks at how such cases have been handled in the past and the legal processes pertaining to minor offenders.
Deadly school fires are not new in the country. Several deadly attacks have taken place in schools leading to deaths. Some of the worst incidents include the Changoli Secondary School in Machakos, St. Kizito in Meru, Bambaluru Girls and Moi Girls High School fire tragedies, to name but a few. Two cases stand out on how children arsonists are tried in Kenyan legal system. In 1991, 19 girls lost their lives at St. Kizito Secondary School in Meru following a deliberate arson attack from male students. 30 students were arraigned in court facing 19 charges of manslaughter. In 2001, 67 boys lost their lives in a dormitory fire at Changuli Secondary School. Suspects, 2 students aged 16, were arrested over the arson attack. And subsequently in 2017, a 14-year-old student was arrested over the death of 10 girls from Moi Girls High School for starting a dormitory fire. Out of the 3 incidents, only one case was prosecuted, where a 5-year jail term was handed over to a former Moi Girls High School student. However, in the case of Changole, suspects were charged with 67 counts of murder but never sentenced. For St. Kizito, most of the charges were dropped against the students, as state was unable to pursue murder charges, with only 8 male students ultimately convicted and sentenced to serve 2 to 3 years. In Kenyan law, a 17-year-old is considered a child, and children involved in crimes like arson leading to death aren't treated the same as adults. Instead, the law focuses on rehabilitation rather than punishment.
If you are above the age of 8, then criminal responsibility upon you can now be brought before court.
According to a constitutional lawyer, Nuruddin Kagai, any child above 8 years old who commits such an offense is criminally liable but can only be tried in a children's court depending on their exact age and the severity of the crime. Criminal liability is divided. For children under the age of 12, the Children's Act provides absolute immunity from criminal prosecution. Children aged between 12 to 14 years are criminally responsible, but there is a rebuttal presumption that they do not understand the difference between right and wrong, while those aged 14 years and older are considered criminally responsible for their action. However, for 12-year-olds and above who commit grave crimes like arson or murder, knowingly planned and committed, can be subjected to standard criminal proceedings.
They will now have to have their charges read to them. Whatever charge they come up with, they have a right to argue for bail. Bail is a right enshrined for every accused person.
For Tumishi girls who are suspected of torching the dormitory, this might be the case. Bentura Kwamboka,